Hello, welcome, welcome. Give us just a few moments to let folks in from the waiting room and then we'll get started here. Good afternoon, everybody. Welcome to our webinar. Today you'll be viewing a webinar um, hosted by Michelle Dellino from Dellino Family Law Group. And the topic for today is financial support in Washington state family law, including child support, spousal maintenance, and more. Briefly, I'll introduce myself. My name is Melissa Rosenberg. I am actually a therapist here in Seattle, Washington, with a specialty with working with clients who are dealing with various aspects or stages or phases of the divorce and separation process. I work with both couples and individuals who are navigating, trying to determine if they're going to separate or to get divorced, or if they're involved in a complex family law case and dealing with the different emotions involved in all of that. Or who are on the other end and trying to navigate their next chapter. So that's my gig, but today I'm here as a moderator for this webinar, and I'm going to introduce Michelle here in a moment. But first, just to let you know kind of how this works today. Um, we're going to be here for an hour or just under an hour, and hopefully you'll be able to leave here with a lot of great information about financial support in Washington state family law. Um, and the way we're going to do that is Michelle is going to, be delivering a lot of this great information, but we also want to be able to take your questions. So the way that we can do that, is twofold. We have either the chat option or the Q&A option at the bottom of your Zoom screen. If you put a question in the Q&A, I will go ahead and pitch that to Michelle, and we'll try to get as many of those questions answered as we can. In the Q&A option, you can put yourself as an anonymous attendee if you'd like. If you don't choose that option, your name will pop up for the webinar folks to see. If you would like to chat the question to me instead, you can put it in the chat and that just comes to me. So I'll get those questions either in the chat or the Q&A and we'll pitch as many of them as we can. Just to let you know, if things are super fact specific and case specific to your situation, and really detailed, it's going to be probably hard for us to answer those questions. And Michelle will probably not be able to answer those questions, but we can try to piece out more general questions from what you're asking. So that's kind of how that's going to work. I'm going to pass it over to Michelle to introduce herself, and then we'll go from there. Thank you.
Hi, thanks for being here. I'm Michelle Dellino, the owner and founding attorney of Dellino Family Law Group. We are a full-service family law firm with offices in Seattle and Bellevue. We actually help clients all over Washington state. I've been practicing family law for 16 years, so you're crazy is probably my normal. We have 15 family law attorneys and a full team, so we really handle all kinds of matters in our office, everything from really high conflict, high asset, complicated stuff to more cooperative and even uncontested matters at times. So today, though, I'm going to focus on talking about financials. We are going to talk about financial support, like that's kind of the overarching theme, and that encompasses largely spousal support and child support. So we're going to talk about those things, but those really aren't the only, you can't really, let's put it this way. You can't really talk about one piece of support without talking about all of the financials, because Washington is, as my friend Kim likes to say, a choose your own divorce adventure state when it comes to financials, which means you really have a lot of flexibility in how you schedule, and how you settle your case. So that means sometimes you might be taking more property instead of spousal support. There's different things you can do. Child support's a little less flexible, but you really need to talk about financials in a whole picture. So I'm going to talk about financials in general, and then we're going to key in on other issues for support, specifically child support, spousal maintenance, attorney fees, things like that. So I hope that that's helpful. What I'm going to do is give you a brief overview of some things. Like Melissa said, we'll take some of your questions. You need to know before we start, I'm obviously an attorney, but I'm not your attorney, unless I actually really am and you happen to be watching this. And if you are, that means we have a signed contract and we have attorney-client confidentiality. But that doesn't extend, whether you're my client or not, to this video. So what that means is if you do actually ask a question and I answer it, it's not legal advice, it's information. So I'm not giving you any legal advice, and you can't take anything I say today as legal advice. You can take it as information. There's no confidentiality, and there's not really an opportunity in a setting like this for us to talk about your individual situation. So like Melissa said, if you ask a question, I might give you a very general answer. It doesn't mean I don't want to answer your question. It means I can't go through the details, and you should schedule a consultation with an attorney or retain an attorney if you have detailed information that you want to discuss. So my goal here today is to have you leave with more information than you came with. And if you watch our video series, you probably know that one of the things we want to do is just make you feel more comfortable with all the different issues in divorce and separation, because there's a lot. It's a whole different language, and it can take a while to really learn it, and it might be something that you never want to learn. But what you're doing is good for you because it gives you a baseline, and it also makes your conversations, hopefully with your attorney, a little more productive when you understand some basics. So anyway, with that said, I'm going to get started. So generally speaking, these are the topics I'm going to cover. We're going to talk about asset and debt division. We're going to talk about separate and community property, valuing assets, the process for that, and allocating debt. Then we're going to talk about spousal support. And this is your vocabulary takeaway. A lot of people know the term alimony. We don't use that term in Washington, but a lot of people seem to know what alimony is for some reason. Alimony is the same thing as spousal support or spousal maintenance. So in Washington, you will hear people use the terms spousal support or spousal maintenance. We'll use those fairly interchangeably, okay? And they mean the same thing as alimony. So if your friend's talking about alimony, you're like, oh yeah, that's spousal support or spousal maintenance. But what does it mean? It is basically a payment from one party to the other for support. So we'll talk about the types of that. We'll talk about the factors. We'll talk about the duration and the amount. And then we'll talk about child support. Child support, we'll talk about the statutory guidelines and what that means. We'll talk about how you calculate. We'll talk about adjustments and deviation. Then we'll talk about attorney fees. So attorney fee awards, and taxable, whether they're taxable or not. We'll talk about retirement plans, pension plans, some basics you need to know for that. We'll talk about tax considerations. We'll talk about insurance and benefits, and then a few miscellaneous financial things. So that's kind of a roadmap of the things I'm going to cover today, so you have an idea. As I get started, I'm going to talk about one section at a time, and then I'm going to let Melissa chime in with any questions that you might have. And if you don't have any questions, then I'm going to keep going, so you'll get to listen to more information. Okay, so first thing to know, community property versus separate property. I think it's very important that you understand all property is before the court, and that's probably something you're going to hear at different times during your case. You're going to want to know, what's the court deciding about my property? And when I'm talking about property, what the heck does that mean? Does property mean like this coffee cup? Yes, this is property. But generally speaking, we're talking about bigger picture. We're talking about all property. Property also means a home. It means a car. It means a retirement account. It means a financial account. Community and separate property refers to assets. We're talking about all assets. We are also talking about physical personal property, and this can be confusing for different people. So if you're talking about property, you're probably talking about assets. And people don't really care about the coffee cup or the sofa or the TV. They don't really care about assets like that, unless it's something like artwork or jewelry that can be valued. So put all the personal property to the side. And when I'm talking about property, think about assets, accounts, houses, retirement plans, stock options, all that kind of good stuff. That's what I'm talking about here. So the first thing that you do in a case is you categorize property. Is it separate property or is it community property? What is it? First, it's important to define the two. Community property is property that's acquired during the marriage, sometimes even before if there's a cohabitation period. And so it's property. It's an asset or a debt that's acquired during the marriage between that time and when you separate, when your community ends. And there's a presumption that anything that's earned or debt that's acquired, any assets or debts during that time is community. What does it mean to be community? It means both parties have an interest. How much of an interest? That's a bigger question. But both parties have an interest in something that's acquired during the community period, whether it's an asset or a debt. That's community property. You both have an interest. Your names both don't need to be on it, but you both have an interest. What is separate property? Everything that's not community. So the best way to define that is everything either before the marriage, usually, or before the cohabitation period, if that applies in your case, and after separation. It can also be things like you might have a separate property business that's before the marriage. You might have an account that earns interest that still exists that you had before the marriage. If it's creating income during the marriage, but it comes from separate property, that's still a separate property asset. The most common example of that is if I owned a rental home and I owned it before I was married, and then I got rent from it during the marriage. So that money came in during the marriage, and usually income during the marriage is community, but it's from a separate property asset, so that stays separate property. Other things that are separate property that are acquired during a marriage are gifts. If someone gives you a financial gift just to you, not to you and your spouse, and you keep it separate, that is separate property. If you get an inheritance during the marriage and it's just you inheriting it, not your spouse, then that can be separate property. So first thing that happens is you categorize property as separate or community, okay? And once you do that, then you have to figure out how do you divide it. So before you even get to that point, you talk about valuing the assets, valuing that property. That can be real estate. So if it's a marital home, a vacation property, a second home somewhere, those things will need to be valued, and you'll either usually value them through an appraisal. That's kind of the gold standard way of doing it. You might also, and it is advisable to get a CMA, so a comparative market analysis too, kind of see what your home might be worth that way versus an appraisal. So you'll have to get a value, and then that may or may not be the value that's used, but it's important that you have one. Then there'll be retirement accounts. Those can be 401k accounts. It could be a PERS pension. It can be an IRA. It can be any kind of an account that pertains to that pertains to something that's basically a post-tax situation. So a pre or post-tax situation that's for retirement. So retirement accounts are an asset that gets valued. Then there are business interests. So business interests are going to have a goodwill component for some types of businesses, and for others they're not. But a business valuation is a common thing that you need if you have like a family business or a closely held business to understand what it's really worth when you're talking about division. And if someone's going to keep the business, is it going to be shut down? What's going to happen? So a business valuation. You might also need a valuation for investments. So that can be stocks. If part of that account, and this is the same for retirement, you can have a retirement account where maybe you earned assets that went into that retirement account. Common examples of 401k. I worked at Boeing, let's say, for 10 years before I got married. Then I got married and I kept working there during the marriage for another 10 years. So I've got a retirement account that's kind of maybe 10 plus years here, 8 to 10 years here. So it has both separate and community property. So you would need to get a valuation to determine what part is separate, what part is community, and what's the interest on that, on the separate and community portion. So what's the value for each one? It's not just like you divide it down the middle. It doesn't work that way. The gains and losses are calculated on the real time that each property was separate and community, and what that interest or the losses in any case were. So you need a valuation on mixed character accounts for retirement, investments, taxable accounts, things like that. Then there's personal property, which I touched on earlier. And I like to just really distinguish how this should not be a focus for you in your case. If you're obsessed with, I really want to keep that sofa, and we paid $5,000 for that sofa, and it was the most expensive piece of furniture we ever bought. The bad news for you is that sofa is probably worth like $200 at a garage sale, and that's what the court would give you for it. So a lot of the time people attach emotions, or they have unrealistic viewpoints on what financials are worth. So you want to be really careful about that in thinking about thinking about property. Different though with vehicles. I mean, vehicles, you're also going to look at, is there a loan on the vehicle? What's the condition of the vehicle? What's this actually worth? Like, what's a blue book value for that vehicle? A lot of the times in divorce, we'll just say we're not going to value the cars. Everybody keeps their own unless there's a really big difference. So cars aren't a huge thing to focus on, but it can come into play, especially if there is a loan on it. Jewelry is a different thing. Like if you have jewelry and that can be valued, usually jewelry like a wedding ring or like a watch, or see, I have a watch on, something like that, that has real value. If it's a gift, like let's say my husband gave me a ring and we got married, then it's mine. It's not up for division in the divorce. If you gifted him a watch, that's his. That's not up for division. But if you have things that were purchased together, those are things that you might want to have valued. However, a lot of people just have jewelry that's not worth a lot, and then it falls under kind of the big property umbrella where you don't worry about spending a lot of time and money on that. Collectibles are different. If you have collectibles or you have art, it usually comes into play with art or other kinds of coin collections, things like that. Then we might want to get a value on that, because that's subject to division, right? So you want to know how much it's worth. So if they're keeping the coin collection, you want the value of at least half of it, right? So you need to get a valuation done to do that. So anyway, there's a little bit to know there. Then we talk about how these things get divided, right? And what does that actually look like? Financials don't ultimately get divided till the end of your case, typically in a mediation, sometimes in a trial or an arbitration, but financials get divided much later. They don't get divided permanently on a temporary basis. You can say who's going to pay what on a temporary basis in a temporary order, who's going to have what money temporarily, but you're not dividing up the accounts. You're not saying who gets the house. You're not doing any of that until the end of your case. So it's really important to know. And that can be very frustrating, but that's how it works. That's why it's the end of your case, right? That's why it's called settlement. So negotiation or mediation are usually the most common ways that financials get divided. But like I said, other times it might be divided by a court or an arbitrator. And then we could talk about how that happens as well, like as far as who gets how much. We could touch on that too. Debt is the same thing, though. It's important for you to know. So community debts, they still have to be divided. Somebody has to take them. Separate debts typically remain with the original owner. Here's the thing to know, though. In longer term marriages, marriages that are more than 25 years, separate assets and debts can be divided. It doesn't always happen, but there is case law in Washington that allows it. And sometimes in a longer term marriage, to do what the court calls equity and equalize people, you might be in a situation where separate property gets divided, especially if one party has a lot more, or it might be handled with one party getting more of the community. So certain considerations in longer term marriages are important. So that is a very, very quick and high level overview of property. Before I give a little more information, move on to spousal support. Is there a question or two that you'd like me to answer, Melissa?
Yeah, we just had a question come in here. Can you discuss how student loan debts incurred during cohabitation, maybe prior to the marriage, would be handled? Are they generally community or individual if that student loan debt was acquired before?
Well, generally speaking, you're asking about this person's asking about student loans before the marriage.
Before the
Generally,
marriage, but during cohabitation.
yeah, and let's talk about that. I'll talk about committed intimate relationships in a minute to answer this question. So, student loan debts are like any other debt. If it was during the marriage, I realize this one's not, it's community debt and it was for the benefit of the community. There's an exception to that, and there's case law on this too. So, and I'm going to talk about this, then come back to really answering your question. I'm not forgetting. So if you took out, let's say you went and got a master's degree in your marriage and you did it because you're going to get a higher paying job or something, and then you get divorced like right after you finish. So yes, that debt was acquired during the marriage, but the marital community is never going to realize the benefit of it. Like that's never going to happen because you're divorced. And so now you're going to get the benefit of it. There's case law that says in that situation, the debt could be treated as a separate debt as far as being allocated to you because the community is never going to get the benefit of it, especially if the community paid for the degree. That's a whole other question too. But anyway, if the community is not going to get the benefit of it, then you may be the one taking the debt, but it is still a community debt if it's acquired during the marriage. If it's acquired before the marriage, this is where committed intimate relationship law comes into play. So a lot of times people will live together before they get married. Pretty normal thing, right? And if you do that for a period of time and you continuously cohabitate, you pool resources, you're supporting each other, you're doing all the things that a married couple would do, you have a marriage-like relationship, but you're not married yet, you could be found to have a committed intimate relationship, which would expand the scope of the community and would mean that community assets and debts actually starts earlier. That could totally happen. That is not a given in every case. Just because you got married and you lived together beforehand doesn't mean that if the student loan was taken out, that it's going to be necessarily community. However, sometimes it is. If you were in school, you guys were living together, and you were engaged during that time, you probably have a good argument for it because then the community realized the benefit of it because you had a job based on that degree. So a lot of the time, you kind of, depending on how long you were living together beforehand and the different facts. And this is a very fact-intensive analysis. There's 5 factors to consider when thinking about a committed intimate relationship. And I'd really have to know more about those to know your situation. But a plus in that situation is you get a degree, then you get married, you work during the marriage, the degree benefited the community, so you've got an argument there. But you also have to have the committed intimate relationship to have that actually be community-like property. Long answer to your question is it depends, but you may have a case for it. Hard to say. So I hope that helps. I could take 1 or 2 more.
Yeah, okay, if a spouse does not disclose all the accounts in discovery, what's the course of action here?
Well, if they're not disclosing all the accounts in, uh, if, put it this way, if the other party's not disclosing accounts, how do you know they exist? So, if they're not, or they're just refusing to, it's two different situations. If they're refusing to, then you bring a motion to compel and they have to disclose them. If the court orders them to, and you're probably going to get attorney fees. If you are just speculating that they're not giving you something and you think it might be out there, but they're saying, hey, I don't have anything else to give you, your attorney has subpoena power and could subpoena. Sometimes we'll go on what I would call a fishing expedition. Someone's like, I know this person has accounts. I think they have them at this bank and they're not giving them to us. We'll send a subpoena and the bank will send us what they have for this person. And then the person swore they had no account at Wells Fargo, and all of a sudden we have 3 accounts. Then they're in a bad situation, the other person. So you can do things like that. You can look at a credit report. There's a number of things you can do to track down assets, but if they're just refusing, the first order of business is a motion to compel.
That
All
makes
right.
sense.
One more, or should I go on?
I got one more here.
Okay.
Inheritance. Maybe we talk briefly just in general about inheritance, but this is a specific question. If someone uses inheritance money to pay or mortgage for a family home, which is community property, can that person say now that the home is considered separate property because they used inheritance money to pay a small portion of it?
Say that again.
Yeah. So there's a family home and somebody's using inheritance money to pay for pay for the mortgage. Can that person claim that the home is considered separate now because they were
No.
using the inheritance money to pay for some of it?
No, the character, this is a great question because it lets me say my favorite thing. The character of the property is established at the time the asset is acquired. That means if it's a community home, you bought it, you're both on the title. You bought it during the marriage and you're both on the title, then it's a community home. And I'll talk to you about liens in a minute, but the character of the home is community. If I bought a home before marriage and you came and lived there with me and we paid towards the mortgage, the character of the home is still separate because it's when it was acquired. Now you can change the character of a home by either commingling or transmutation. Transmutation is really how you change the character. You add someone else's name to something and you have an intent to make it community. In this case, you have a family home and someone's like, well, I used inheritance to pay towards the mortgage. Well, the character of the home is still community. The real question is, do they have a separate property lien on the home? And that means they use separate property to pay part of to pay part of the mortgage. So do they have a separate property lien? Really depends on the circumstances. Can they show that that inheritance wasn't intended to be a gift to the community? Can they show that it was supposed to be a loan to the community? Do you have a prenuptial or postnuptial agreement that addresses that? Were there also community funds paid for part of the mortgage? What's the source of the down payment? The most common aspect of a community or a separate lien is if, let's say, somebody used inheritance to put money down and you put part of it was community and someone chipped in 50,000 inheritance or whatever. They probably have a $50,000 plus interest right to reimbursement from the home. But if someone made payments from separate property, it's going to come down to, was that a gift to the community or was it a loan to the community? So, but it doesn't change the character of the home. The home is still community. So long answer to your question, but the big takeaway there is it's nuanced. You need to talk to somebody about it in detail. You don't want to miss out. Like if they're telling you they have a right to reimbursement, you want to know if they really do. So, okay, I'll take one more before I go on to talk about spousal support. So I probably could talk about community property all day, but anyway, we could do that another time.
Sure, this is an interesting question. How do U.S. courts handle foreign dowry claims? In a situation where a marriage began abroad, where there's like a large dowry obligation imposed, like even $500,000 if a husband separates from the wife. Do U.S. courts do anything about this? Do they have any
No, I mean,
involvement?
probably not. It's going to depend on the specifics of your situation. Is there a contract that needs to be enforced? Is there a jurisdiction over that? I mean, this is a fact, especially a large dollar amount, fact specific questions. I can't address that here. I'm sorry.
Yeah.
Yeah.
Okay.
Okay. All right, let me talk about spousal support and then we can come back and take more questions at the end if there are any. So spousal support, also known as spousal maintenance. I told you what it was earlier. It's a payment from one party to the other for support, like it sounds, also known as alimony in other states. So types, one is temporary support while the case is pending to maintain the status quo. I move out, I can't pay my bills, the other party makes way more than me, I might need temporary support. If we're still using the same joint accounts and we're getting along and they're not shutting me off and they're paying all the bills, you might not need a temporary financial order dictating spousal support, but maybe you do. Maybe you want to handle your own finances, you guys are living separately. In a lot of cases, temporary support is awarded to maintain the status quo during the case. Then there is post-divorce support, so long-term support, or in some cases, permanent support. For post-divorce support, that is payment after the divorce is final. So here's the thing. You want to know how long you're going to get financial support. You want to know how long you're going to get spousal maintenance. I'm going to tell you it depends. We in Washington do not have what I would call a statutory formula like we do for child support. And some other states do, but a lot of them don't. And that would just be like, you make this much, you make this much. It goes into a calculator. Here's how much you get. No, no. In Washington, there's a lot more to discuss. So in Washington, there's a general guideline for how many years of marriage might be maintenance, but it's still going to come down to different factors to determine whether maintenance is really even appropriate and how much. So as a general rule of thumb, and again, very general, I've seen less, I've seen more, especially if there's disability or incapacity or something like that. But generally speaking, every 3 or 4 years of marriage equals 1 year of spousal maintenance. So let's say you were married 12 years. That's a midterm marriage. It's more than 5 years. Maintenance is very rarely awarded in a short-term marriage post-divorce, which is 5 years or less. But let's say you're married 12 years. Midterm marriage, common spot for people to get divorced. Somewhere between 3 and 4 years of marriage is 1 year of maintenance. So it could be 3 or 4 years of post-divorce support, depending on the factors and depending on the incomes. And just because you're married a certain amount of time doesn't mean anybody's getting spousal maintenance. Things the court is going to look at is how long was the marriage? What are your financial resources at the time of the divorce? And what are the parties' earning capacities? What are your financial situations? Has one party been a stay-at-home parent while the other party's been the breadwinner? Does one party recently back in the workforce? Or did they both work and just make not the same amount of money? What are the contributions to the marriage, basically, as far as homemaking, supporting the career of the other? Really common, someone will move different places to support someone's career, but they're not making as much because they were playing a support role. So that's important, and that's why maintenance exists. What was the standard of living during the marriage? There's no lifestyle maintenance, which is you get to maintain the same standard of living unless you're in a long-term marriage of 25 years or more. And then there might be, depending on how extreme the standard differences. But in a case where you have kids, you don't want the court doesn't want one person living in a studio and the other person living in the house, right? Because kids are going to go back and forth and they should have comparable living environments. So that can come into play as far as standard of living. And then there's going to be factors like the age, the health of the parties, and the time needed for education and retraining. So, maintenance is a complex question. Doesn't apply in every case. So the first thing you want to know is, does it apply? And then you get into what does it really look like? Okay, because it can be a big range. Duration and amount. I mean, it's typically limited to depending on the type of marriage, what the purpose is. If it's a short-term marriage, then that's like a backward-looking marriage. Same thing for property division. Nobody's relied on the community long enough, so the principle is in Washington is people are kind of put back where they started and that's it. Usually property gets divided equally. Maybe there's no maintenance, or if there is, it's very little and everyone goes on their separate ways. In a midterm marriage, which is really more like 6 years up to 24 years, then you might be looking at a disproportionate division of property depending on the parties' situations, and you might be looking at maintenance. Or maybe you're looking at more of an equal split of the property and maintenance. Like I said, it could be choose your own adventure. Really depends on your circumstances. In a long-term marriage of 25 years or more, parties should be equalized. And if the parties aren't working, then there's not going to be maintenance unless it is in the form of, equalizing Social Security or something along those lines. So it just really depends on your circumstances and the purpose. In a midterm marriage, which is most marriages that are ending in divorce because it's the longest period of time, it's very normal to hear someone say maintenance is rehabilitative. And that is a principle. It's rehabilitative because you're not going to get it forever. So it's time for the transition and for one person to get retraining or to become financially self-sufficient. So think about the intent behind maintenance too as you build your maintenance case. Are there any questions you want me to take before I talk about child support?
Yeah, there's a handful of questions here. Okay, what about a business that someone owned and operated long prior to the relationship? If there was no income ever derived from it during the relationship, is your partner entitled to any portion?
Well, again, so this was before the relationship.
Yeah, the
If
business
before,
existed before the relationship.
yeah. And if it was before the relationship, this is really the important thing to talk about. This is really the important thing. Character of property. Before the relationship, that's a separate property business. So the person whose business it's not, um, you know, they don't have an interest in it. Here's the thing though that I'm trying to think about the best way to explain it without making it really confusing. Income during the marriage. Income during the marriage is typically community property, reasonable income. So if you have a separate property business, but you're getting a W-2 for a certain part of income, right? Like if you're getting a W-2 and you're getting some income, that's your reasonable salary. So you're drawing that salary. So it's not like nothing is community, potentially, and not every circumstance, the reasonable salary, depending on how you're paid, that might be community. But then the value of the business, the goodwill value of the business, what you might be paid on a K-1 or any number of ways, and this is all very fact specific, that portion may be separate. But the business itself is not community property. The business itself started beforehand as separate property. Perhaps some of the wages are community. So I don't know if that helps, but that's business ownership can be complex depending on structure, any number of things like that.
And what about using community income to contribute to capital in that situation? If you use community income to
Yeah.
contribute to the
If
business.
you can make, and again, too, this is again the same thing I said earlier, it's still a community business, but if you made, I'm sorry, it's still a separate property business, but if you made capital contributions from community, there might be a community lien on the business. So it doesn't change the character of the business, doesn't give you part of the business, but it might give the community a lien on the business if you made a capital contribution from community. I hope that makes sense. It really matters how you are characterizing things like that and determining what the interest is. So I hope that's helpful.
Thank
Okay.
you.
Anything else before I move on?
Another one, how often is a lump sum possible when you're doing property division or whatever you're
A
talking?
lump sum as far as maintenance or property division?
I don't know. Maintenance, property division. I'm not sure when this question came
Sure.
in.
A lump sum, well, I mean, and you've always talked to an attorney because that's such an attorney term. I'm always like, oh, a lump sum transfer payment. Yeah, real people don't
Okay, they
talk
say
like
they're talking about maintenance.
that. Okay, real people don't talk like that. So good for you. So a lump sum for maintenance, which basically what they're talking about is they're talking about a prepayment. A prepayment for maintenance is a lump sum paid up front rather than me making you a maintenance payment every month. How often is it possible? It's possible when you agree to it. Is a court going to order it? Not very often. Sometimes, but most divorces, 90% of divorces aren't decided in court. It's like I said, it's a choose your own adventure. Kim Muska is wealth advisor at UBS, and she's also a CDFA, a certified financial analyst that deals with divorces. She's on our meetup group. You may have seen her there if you've been on our other programming. Anyway, she's awesome. She's also a friend of mine, and I like to give her credit because I don't like to steal it. It's so the best way to describe things, and it pertains to your question. This is a choose your own divorce adventure state. So you can propose a lump sum, and here's the fun part about it. If you propose a lump sum, fun to me because I love this stuff, not fun to you, but if you are proposing paying a lump sum, you can propose a slight discount on prepaying it. So if I'm going to decide between paying maintenance for 5 years every month, or I'm going to give that person all the money up front in that lump sum, you could propose a discount. It's not going to be a huge discount, but you might be able to get a 3 or 5% discount, maybe. Maybe not. And the reason why is because of the time value of money. If I'm getting 5 years of maintenance up front, I could invest that and make money on it, right? So the other person should get a discount, so of some. I mean, but it's not a huge discount. Anyway, a lot of people prefer to get a lump sum up front so they can invest it and have that security. A lot of people don't want a lump sum because they want to buy a house or something and they want to be able to show those recurring payments, or they just don't want to deal with a lump sum. So how often is it possible? I mean, we do it all the time. It happens all the time in this office, in many offices, in many places, but it is usually what's best for the parties, and it's the result of careful negotiation and understanding what your options are and what's best for you. Because what's best for one person is not best for the other. So anyway, long answer. I really like talking about maintenance if you can't tell. So lump sums are possible. There's no universal rule. Sometimes you can't, there's not enough property or assets to afford to pay a lump sum, and that's not uncommon too. You might love to get it, so you've got the cash in the bank, but it's not really feasible with what the assets are. So that's the kind of thing you need to think about. It might truly need to come from that post-divorce income. But other times, the other thing you could do is you could say, sometimes we'll term, this is the last thing I'll say about it. You might term something a lump sum, and you might offer a discount and say this person's prepaying the maintenance and it's coming out of giving someone more community property. Or sometimes a less experienced attorney might not call it a lump sum, and they might just say we're giving you more of the property instead of maintenance. It doesn't mean that's bad, but you want to be very clear whether it's a prepayment of maintenance or not, just so that issue's clear and you're dealing with the maintenance issue in your final orders. Anyway, all right, I'll take one more and then I'm going to move on to talk about child support.
Okay. All right, if there's a situation where one spouse buys a home with their parent but doesn't tell their other spouse during the marriage, what happens with a situation like that or that property?
I'm wondering how they were able to buy a home during the marriage, because in Washington, since it's a community property state, even if you're not on title, you would have had to sign a quitclaim deed, quit claiming your interest away, or you'd
Mm,
be on. So I can't answer that. I'd have to know more.
okay. Okay.
Okay.
Great. Let's ask one more.
Yeah.
Um, Somebody bought a house during their marriage using a large percentage of the down payment coming from separate property money before the marriage. Okay. So big portion of the down payment came from their own money before the marriage
Okay.
and paid all the mortgage themselves.
They
Were they,
paid themselves. Did it come from the income that you made during the marriage? You didn't pay it yourself. It maybe
okay.
it came out of your paycheck, but that's community money. But I
Okay.
get it. You paid most of the down payment from separate property. Are you
Yeah.
wondering if you can get your separate property back?
They're wondering if the property would be divided equally or if there would be a larger proportional share to the person who paid more into it.
No, the person who paid more, if you use community money to pay it, even if it came from your income, nobody's going to give you necessarily more of the house. And it's part of the bigger property division. This is what you have to understand. All of your assets and debts are on a spreadsheet. The house is the only thing you're dividing. We're not going to say we're going to go 50-50 on the house, 60-40 on this. No, it's a global picture of your finances. So you really, you kind of need to see it to really understand that if you don't know what I'm talking about. But to answer your question is actually a really good one. It's a great one. And I kind of touched on it earlier. If you make a separate property down payment, like let's just say for fun, I paid $500,000 down on a really expensive house and it came from my separate property. And then maybe the community put 50,000 down, or maybe they didn't put anything down, whatever. But both parties are on the title. Everybody has an equity interest in the home, but you have this down payment. So a couple different ways can be handled. Some people will agree to just give everybody, like, I put down 500,000, my husband put down 100,000. We each get our money back off the top, and then we're doing an equity division. That's not what the court's going to do. And that is, if you're negotiating for that in a prenup or something, that's one thing. But generally what will happen is the parties will either own the home proportionally if you agree to that, or what will happen more likely is you'll get your down payment back plus interest. So you might get your down payment back plus interest, but the equity is community. If you paid the mortgage from separate property funds, like you paid it from an inheritance or you paid it from, a taxable account that you only contributed to and had before the marriage, then you may also get, some credit for that, maybe. But the bottom line is usually people pay the mortgage from wages or money earned during the marriage. And that money, even if you paid it, is community. So there's going to be an equity interest in the home for both parties if it's community home, but you're going to have a separate property lien on the home for your down payment, and that's usually going to be down payment plus interest. So also something that you need to get evaluation on. So I hope that that helps. Anyway, okay, I want to talk about child support so that it doesn't get left out. Really important. It's like the easiest part of a divorce, but sometimes it's really contentious for people to even think about. So child support has a statutory formula. That's why I say it's quote unquote easy. It's not easy, it's just more clear. So statutory formula in Washington is based on the Washington State Child Support Schedule. There's a WAC, Washington Administrative Code. It's 388-478. 388-478, if you really want to look it up, you can see the child support schedule. The factors, parents' income, parenting time, really just meaning who has more, not number of nights usually, and then healthcare and childcare costs are part of the worksheets in determining whether they're included or not, but they're addressed in a child support order. So basically, you look at the gross monthly income of each parent, you subtract out mandatory deductions, taxes, union dues, retirement, although some people make big deductions for retirement, and that is capped at a much smaller amount than a lot of people do. So there's mandatory deductions that qualify under the child support schedule. Then you look at what the net income is, and then you allocate the proportional support obligation from one party to the other. Then you add costs for health insurance, uninsured medical, and childcare. So let me break that down for you. Party A makes $15,000 a month. Party B makes $10,000 a month. The combined income is $25,000 a month. And then you're going to net that out to whatever the net income is. The maximum income where the child support table taps out is $12,000 in combined income. So a lot of people in this area combined are making more than that. So your child support will tap out at a certain point. Then you're looking at who's the primary parent? Is there a primary parent that has more nights? And then you take it and you say, one parent makes 66%, one parent makes 33% of the total amount. Let's say the parent making 33% has the kids less nights. They pay their 33% of that number to the other parent. It's not that complicated. It sounds more complicated than it is, but it's just really not. And then there are things that are not covered by child support. What is covered? Well, what's covered are basic life necessities: housing, transportation, putting gas in your car to drive the kids, paying your rent or mortgage, clothing, and food, like basic life necessities. What's not included, extracurricular activities, work-related childcare, and uninsured medical, like co-pays, meeting a deductible, out-of-pocket costs like that are not covered. So that's something for you to think about. The main things people are paying out of pocket are work-related childcare, uninsured medical, and extracurriculars. Those are really the main things. And then tuition, like educational expenses. If your child's not going to public school and they're going to private school, that's going to be addressed as well, and is usually proportional share. Proportional share, or pro rata, a term that you might hear, is I make 66%, parent B makes 33%. We each pay our proportional share of those things. That's how that works. The transfer payment, you'll hear transfer payment, is the payment from one parent to the other. So there's the two parts. There's the transfer payment, and then there's the proportional share for out-of-pocket expenses. Those are the two components of child support. Every child support order will address who's paying for the medical insurance for the child. Is that premium divided pro rata, or is one parent taking the premium and getting a credit for it on the child support worksheets? There's a couple different ways that you can work that out. So you're going to want some help with that. But anyway, that's kind of the main thing to know. There are times that you can deviate from what that worksheet says. Like, we have a calculator that will calculate it based on the statute after we take out the deductions and put in the insurance or do any of those things. So can you deviate it from it? Yes. There are reasons for deviations. The most common one is time spent with the children, and it's not a guarantee, but let's just say both parties are on a 50-50 parenting plan and they make the same amount of money almost. You probably will have something where there's no transfer payment, just paying proportional expenses. And the reason why is because people have equal time and equal resources. Or you could have a 50-50 where one parent makes considerably more and is still paying child support, but maybe they're getting a little bit of a deviation, like a deviation down, a little less support, because they have the kids in their home half the time. And so you're not paying for food, clothing, everything, 75 or 80% of the time. So there's different reasons for deviations. They're not a guarantee. And if it creates a hardship for one parent, somebody's probably not going to get it. So those are kinds of things that you'd want to talk about. There can be high income deviations, but they're very rare and hard to get. It's more likely that you'd get a high income deviation if there were special needs that one party really needed to pay that the other party couldn't afford for a child. But those are really, really rare. You don't really see upward deviations very often. Anyway, so that's something to think about. Residential time is the most common reason for a deviation. Okay. Any other questions on child support?
Yeah, there's a few. Okay, if somebody is behind over $10,000 in child support and only pays once a year and doesn't work and lives with their parents, how do you hold them accountable?
Well, hopefully, hopefully you have one of two ways. If you have child support through the state, you should have a DCS officer. You should have somebody on your case. And here's the thing. There's two things you can do in a child support order. You can agree to just basically private pay, so the other party just pays you, or you can agree to support enforcement through DCS. That's what most people do, and then they'll take it right out of that person's paycheck. So if you have private pay, you should change to support enforcement. If you are, the most common way to avoid that is someone's getting cash pay. It's even harder and harder and harder to do. But if you have a DCS support officer, you should talk to them about it. If someone's behind too, things like they can't get a passport, they can't get a driver's license, like those things, if they're behind in support, can happen. But if they're hiding income, that can be a more difficult thing, and you might need to actually seek an administrative hearing. You might need to try to open discovery. You might need to get their financials. If they're getting paid through a way we see people doing it is getting paid through Cash App or Zelle and trying to hide it in some other account. You might need to get an attorney to dive into it. But really, I would talk to your support enforcement officer and say, hey, this person is hiding money. But if they're not hiding money and they just don't have any, you can't get blood out of a turnip. And so don't throw good money after bad. If this person just doesn't have any money and they're a slacker and they're just like chilling with their parents as an adult and they're not working, they don't have any money to give you. So they're going to have a judgment against them. And eventually, hopefully, their account will get garnished if they ever do get money, or they want to get a driver's license, or they want to leave the country and get a passport. Maybe they'll pony up and pay it then. But don't throw good money after bad. Don't, sometimes people think they're hiding money, but really they're just not working and you can't get blood out of a turnip. So anyway.
Okay, I have a couple more child support related questions.
Okay.
Somebody's asking, is a lump sum ever possible with child support,
No,
excluding certain provisions like healthcare, etc.?
no,
No? Okay.
no, because child support changes. This is what I was going to say about support. And I'll just say it now before I go on. Child support changes. If you'd want to change it, or if the facts warrant it, you get a support order. Sometimes I'll have parties that get divorced and I don't know, kids are 2 and 5 and they'll never change the support order and it stays the same the entire time. That can totally happen. No one's going to automatically change your child support. Or you could be in a situation where the parties are 3 and 5 and every 2 years a parent moves to adjust support. The Washington state statute says that everybody can adjust support if they want to bring an adjustment to bring child support, the transfer payment and the proportional share current based on current income every 24 months. Some people will do it like clockwork every 24 months. You can do that if you want, or it might never happen. It's just a question of, is someone going to seek an adjustment? If it's worth it to them because there's been a big change, then they probably should. But a lot of time you don't know and you're kind of guessing. The other way to change support is a modification. You can bring a child support modification at any time based on a substantial change in circumstances. If someone loses their job, if someone becomes disabled, if there's a substantial change and child support needs to change, and it doesn't matter if it's been 24 months or not, you could bring a modification to change it based on those circumstances. So that's something that you should know. So the reason that you don't lump sum, child support is because it can change. And so there are two things in your divorce that the court has final say over. Like I said, finances, maintenance and property division. Choose your own adventure, decide on anything you want, and the court's going to sign off on it. I could say I'm giving my husband 95% of everything, and the court's going to be like, they don't care. They're not going to say you're stupid, don't do that. They're going to sign it. That's what's going to happen. But child support and parenting plans, the court is going to scrutinize those and they can reject your order. So a court is going to reject an order that has no child support unless there's a basis for it. And a court is going to reject a lump sum child support order. It's not, you can't do it.
Okay, so even if you're the parent who maybe is going to have the income that goes to higher later, you're the one paying the child support. So you're wanting a lump sum because that's going to protect you for bigger payments later.
You can't do it.
Yeah. Okay.
You can't do it. Nope. And I wouldn't agree to it either. Like a lot of times people will agree to something outside of the child support order. It doesn't matter. It's not enforceable. It's not the order. A lot of time it really happens too if someone is like, parties don't like get divorced right away, or even if they're unmarried parents and one party's giving the other party a bunch of money, and then someone goes and says, you haven't paid me child support in 5 years, and they seek support back 5 years in an unmarried relationship, and the other person is saying, hey, we had an agreement. No, you didn't. It's not an order. So don't do something outside of the child support order, or don't term something child support that's really not, because you won't be able to do it. Yeah. I get it too. A lot of people just want to pay it up front or front load it. Can't do that. One thing in the child support order the next thing I was going to touch on is post-secondary education. When does child support end? It ends when a child turns 18 or when they graduate from high school, whichever is later, unless one party seeks post-secondary support. Your child support order will either order post-secondary support or it will reserve it. 9 times out of 10 in a competent child support order, it reserves it. And what that means is you deal with it later, because when your kid is 4 years old, how do you know what they're going to do for college or post-secondary education, or even if they're going to go? Are they going to go to private school? Are they going to go to an in-state school? Are they going to go to a trade program? You have no idea. What's your financial situation going to be in 14 years? You don't know. So it's reserved, and then the parties can raise it when it's closer in time. But if you don't raise it, you lose it. So if there's anything you take away from this, if you're thinking about post-secondary and your kid's going to be a senior, you better be ready to get it. Otherwise, you lose it if they either graduate or turn 18, whatever's later. So that's really, really, really important for you to know.
Mhm.
Okay.
So, along that same lines, can child support be received for a child over 18 who lives at home with one parent and doesn't work due to special needs?
If you motioned for child support, for post-secondary support before that child turned 18, maybe.
The special
But
needs is the reason. The reason is because they live at home and they're, not able to work due to special needs situation.
are they on disability? Then they should be getting their own disability. I can't answer that question. That's too
Yeah.
fact specific. That's something you want to talk to an attorney about. But if they're already 18 when you're getting divorced, probably not.
Yeah.
If it's an issue that you can incorporate in sooner, maybe, but I can't answer that. It's
Okay.
too specific. Yeah. Last thing is I will come back and take some more because we have like 10 minutes. I want to hit on the last closing items just so I cover them all. Attorney fees and costs. Attorney fees, there is the statute in Washington in divorce only, not unmarried parents, is need and ability to pay. Attorney fees are also addressed under the parentage and paternity statute too. But need and ability to pay, you can have somebody that has a need seek fees from the other party, and the person who has the ability to pay might have to pay. But they're going to consider the financial reasonableness of the fees that you incur, and they're going to consider what the financial resources are of the parties. But getting attorney fees in a divorce is definitely possible. The other reason that you might get fees is what's called intransigence, one party acting in bad faith and making things cost more because they're doing that. So fees, or asking for fees, is a very common part of divorce. You need to know that. People want to know if they're taxable. Generally, they're not deductible by a payor. So attorney fees in domestic cases are generally not tax deductible. Sometimes somebody will be trying to tell me they want to get a tax deduction for the fees they paid, and I tell them to talk to their CPA. I can't give you tax advice, but I can tell you, generally speaking, in domestic cases, tax exemptions don't apply. So that's good for you to know. Last thing I want to touch on too is retirement and pension plans. If you have a pension or a 401k, you're going to have to divide any ERISA governed plans, like pensions, 401ks, deferred compensation, by a qualified domestic relations order. I'm telling you this because you might hear the term quadro. Quadro refers to a QDRO, qualified domestic relations order. This is an order that's done post-divorce to actually divide those kinds of plans without tax implications. So you have to do that, and that's usually something that's done post-divorce. Military and civil service pensions, there's domestic relations orders for PERS and TRS division as well, similar to a quadro. You'll have to have a specialized order for dividing those plans. So that's something for you to know. Tax considerations, last thing, filing status, married filing jointly versus married filing separately for the year of divorce. Most of the time, people want to file joint because it's better for them financially. Sometimes they don't. Sometimes you might want to cooperate on a joint return. And people might even say, let's stay married to the last end of the tax year and file the divorce in January. That's not uncommon. We actually end up doing that a lot. So the year that you get divorced, if you get divorced in June, you guys are filing a single return that year. If you are married for the entire year, you can file a joint return. So, and you're going to have to cooperate on a joint return. Otherwise, people will go married filing separately. So anyway, try to be cooperative, at least through attorneys, on that part of it. Dependents and credits, who gets to claim the children. So usually exemptions are split. If you have two kids, one parent claims one parent claims the other, as long as they're actually paying support. Sometimes people will negotiate, because if you're a high income earner, you don't benefit from that at all. So maybe you negotiate to give the other person both exemptions as part of your case. But anyway, IRS Form 8332 is required if somebody who is the non-primary parent is making a claim. So there's a lot of little things that get worked out and included in your order. And usually we like to put in the order that the parents will cooperate on signing that form if it's needed, just so nobody can change their mind later on being difficult. Um, Property transfers are generally tax-free when they're incident to divorce, but in certain circumstances where there might be tax implications, we might ask you to talk to a CPA because we are not CPAs. I know a lot about tax and finances, but I'm not a CPA, so I can't give tax advice. Insurance and benefits. So health insurance, you might want to consider getting your own coverage, or as opposed to COBRA, because COBRA can be expensive if you were on your spouse's insurance. You're not going to get kicked off their insurance until divorce is final, usually the last day of that month or sometimes the day of divorce. So, that's something to think about and talk to your attorney about. Life insurance typically terminates on divorce. So if you really want to continue to pay out your ex-spouse, you probably need a new policy saying it's a post-divorce policy. And some life insurance policies have a cash surrender value. If they do, that's an asset in the divorce. So anyway, that is a lot. There's business valuations and practices, there's marital debt, there's enforcement and collections, there's all kinds of little things we didn't get to talk about in great detail, but we covered all of the basics. So I have 5 minutes. I will take like maybe 2 more questions, but I will tell you this. Financials and financial support is not the same for everybody. My favorite is when you have somebody that's like, oh, well, my friend's divorced, this is what happened, or I'm being told this should happen. Well, they might mean well, but they don't have a clue about your case and they're not your attorney. And they probably don't have a law degree. Or if they do, and they're a family law attorney, you'll probably be working with them. An employment attorney doesn't know, just like I don't know about employment law. So talk to somebody that knows. It does not have to be me or anybody in my office, but if you talk to anyone, talk to an actual family law attorney about your case, because this is your life, this is your next steps, and this is the money that's going to sustain you in your next chapter. So it's really important not to give up too much and not to get too little. So talk to an attorney. I'll take 2 more.
Okay, for child support adjustments, who bears the legal costs of the process of that adjustment?
Usually the parties bear their own costs, but if one party makes a lot more than the other, you may be able to seek fees. So it just, and if it's part of a marriage and it's post-divorce, if it really depends on your circumstances, but usually someone bears the own costs. And an adjustment is usually a pretty simple process. It's not too expensive.
Mhm. Okay. And then what if you talked earlier about post-secondary support. What if you're getting a divorce and you already have a child in their first year of college? Can you get post-secondary support for that?
You can negotiate it as part of your divorce.
Okay.
Yeah, I mean, and getting a court to order it is really going to depend on what the parties have been doing and the circumstances. So usually it's negotiated, but like if the kid is taking, I mean, it depends. Like what a court would do is probably going to be different than what you would negotiate, but it's definitely an issue for discussion. Are there 529 plans? Is another consideration that we like didn't even talk about. Is there a Washington Get plan that you have from before it was shut down? Is there a 529? What's the circumstances? Those resources need to be exhausted first, usually before post-secondary too. So, and what's the status quo that you established? So all kinds of questions. So, what we're going to do is provide some information here. I will tell you this too. This is just a thought, is if you are working with an attorney, you want to ask that attorney, what other financial experts do I need? Like I mentioned Kim earlier, and I use her on a lot of my cases. Sometimes I might use another financial expert too, but she's my go-to because she knows what she's doing. So
Somebody's actually asking specifically for her contact information in the chat.
okay, I can tell you her name, but the bottom line is she's going to want you to be working with an attorney. So, and if you already have an attorney and they have their own go-to people, you probably want to contact their people. So anyway, her name is Kim Muska, M-U-S-K-A, and she works at UBS. So I'm not going to put her information up here. I don't have her permission to do that, but you can look her up. And if you're working with someone in our office, we work with her all the time. So do other firms. But if you're working with a different attorney, you might want to ask them, who do you use on the financial side that can help me? I know I don't use a financial expert in every case because you don't need one in every case, but in some cases we do, especially if you're trying to help someone plan for their next chapter. I'm not going to talk to you about what your finances are going to look like in 15 years with this asset allocation. She is going to do that. So especially too, if you're paying, you want to know what assets is it best for me to tap if I'm paying. So it's really good. And an attorney will often bring somebody like that on board to help you. But anyway, contact Kim if you want to. That would be great. Anyway. So thanks for coming. You guys had a lot of really, really good questions. I wish I could have answered more of them. This will be available on our video library on YouTube. There's a whole host of, we've been doing this for a while, so there's a bunch of things up there. We did our meetup group just last night. We usually do our meetup group the last Wednesday of the month. There won't be one this Wednesday because it's Memorial Day week and a lot of people out of town. So we did it last night. But we do them virtually on Zoom every month. Kim is there. I am there. Melissa is there. Amy Alpeza, who's a certified real estate divorce expert, is there. Cindy Scobie, who is a certified divorce lending professional, is there. So it's a really good time to come and ask questions. Once a quarter or so, we do them in person. So that's a smaller group, but you can sign up for that as well. So anyway, thanks for coming. Thanks for asking your questions. If you didn't ask a question, but you were here, hopefully you got something out of this. I really hope that you did. And feel free to reach out to us. Otherwise, take care and have a really nice day. Bye-bye.
Thanks, everyone. I will leave the contact slide up here for just a moment. Yeah, please contact Michelle's firm. There's a host of wonderful attorneys there who can answer your questions. If anyone's interested in therapy or counseling services, please reach out to me. And yeah, come again. We have these often, and we look forward to seeing you again soon. Take care.